First, I will repeat the words said by Miha before, and I'm quite sure that also my successors will repeat the same words, how we respect the project and especially the work of dear János, who really did a masterpiece editing our contributions in a book which got such a good review as we heard from Professor Rakushi this morning. And the second thing is that I would like to excuse my dear colleague Vasilka, who's not with us. As János explained you in the morning session, she's in Stockholm in another conference, and therefore I will use this chance not to stress my presentation on international field of law, because she's an international lawyer and I'm a private lawyer, and I will put my attention to the private law questions of right to safe drinking water. Okay, I need my presentation.
Would you be so kind as to try it again? Okay.
Yeah, great. So, however, I will start with some international aspects, and since 2010, several countries, especially from Africa and Asia, from Africa and Asia, updated their legal frameworks to reflect water and sanitation and as human rights. The number of these countries is higher and higher, and also in academic literature, for example, the scholar Sereno put the right to water as a subjective human right with direct applicability. But we all know that it's quite simple to put something as a declaration in a legal document, and the real problem is how to fulfill the goal of putting a value in the legal rule, and even if this legal rule is in the highest document in the legal hierarchy, so in the Constitution, or even more in the International Pact of Human Rights or something like this. And we have quite the same discussion regarding the change of Constitution of Republic of Slovenia. In 2000, after 2010, the first discussions in Slovenia began about amending constitution with right to safe drinking water, and someone could expect that such amendment should be adopted with acclamation, but it was not like this. Of course, there are some opponents putting this right in the catalog of human rights in the Constitution. The strongest argument in this discussion was that there is no need. Slovenia has developed quite a huge catalog of human rights, and of course we can also put the right to safe drinking water as part of other basic rights, for example, of the health environment and some other human rights. However, the constitution was amended in 2016, and I think that Slovenia is one of the rare European countries that went in this way and put the right of to drinking water as a special independent right in its constitution. The constitutional provision has four pieces, and I put some stress on basic provision. So the right to drinking water is right of everyone, so is the common right. The second very important legal consequence of this basic rule is that the water is a public good, so the individuals could not impose the property right on the water. This is not new in Slovenian legal system. The same regulation was in force even before. Then the water should not be a market commodity, and the local communities shall provide the drinking water to inhabitants, to citizens, on a non-profit basis. These are four basic pillars of this constitution provision, and I would now touch the implementation, implementation problem of this rule. The basic is the new Environmental Protection Act. It was adopted in 2002, this year, 2022. And in field of drinking water, the new law just repeat the provision of the older one. And surprisingly, in comparison with some other commodities, the drinking water is very, very poorly regulated in the Basic Act. We have just a very, very general provision that drinking water supply is mandatory local economic public service, and local communities have a competence to issue bylaw regulating the supply of drinking water in details. So we don't have a single act regulating the supply of drinking water, but in Slovenia that means 264 different local communities, what means also very different conditions for the regulation of supply with drinking water. Also, the Water Act from 2002 contains some basic provision about the water supply, and this one provides that water supply shall have priority over use of water for other purposes. In this abstract view, quite clean regulation, but we say the evil is in the details. And this year, in summer 2022, there was a severe drought in large part of Slovenia, which affected the water sources for the drinking water supply, and in some places caused a severe shortage of drinking water. Especially in the Adriatic part of Slovenia, city of Koper, Izola, and Piran. It's about 80,000 inhabitants in these two cities. But of course, during the summer, in time of all three cities are on the coast, and of course, number of tourists increase the population of these three towns. And especially in city of Koper, which is also an industrial city, the shortage of drinking water was a serious problem. And the local community started thinking how to solve the problem, and one of idea was to dry the Ljubljana riverbed. The Ljubljana river is the source of drinking water for this region, and the mayor of Koper city proposed to dry the Ljubljana riverbed to enlarge the capacity of drinking water supply for the local supply. On the other hand, fishermen and some environmental organizations strongly opposed the announced measure, because the dry of the river could cause very harmful ecological damage on fishes and other living creatures who living in the water. And it's really difficult to solve this conflict. The supply of drinking water on one hand, and the living animals and living creatures as an environmental damage on the other hand. Thanks God, it was no necessity. The rain, thanks God, came and solved the problem. So nobody need to adopt this very, very sensitive decision. But it was really this question: who is in competence to adopt this decision, to dry the river, to save the water supply, the water supply? So we will see what will happen again. We expect the extreme water, the extreme weather situations also also next years. So the second question is the question that the water supply must, the public, that everyone has right to be connected to the water supply. And we have question of illegal buildings. In our legal regulation for connection of building to the water supply, the building must the building permission must be issued, and without building permission, it's forbidden to connect the building to the water supply. But on the other hand, we have some marginal people, communities with shelters, without any legal building permission, and especially the Roma population. So some in one local community, some Roma people, the name of this family is Hudorovic. This is a very common name for the Roma people in Slovenia. And of course, some Roma people is very good finding a good advocate, and they go to the European Court of Human Rights in Strasbourg. The Roma community, of course, illegal buildings, no direct water supply, and they started with argument that their basic human rights are breached. And of course, they fulfilled the application to the European Court of Human Rights in 2014. The municipality installed the water tank in this community, and this water tank was regularly filled with fresh water by the firefighters. So it's not also these Roma people were not without water even in the summer. So the European Court of Human Justice considered that the authorities in this case ensured that applicants had access to safe drinking water through this concrete measure, and rejected the application of this family. Another case which is quite interesting is a question of water connection in case that some people technically could not be connected to the public water line system. For example, in this case, the decree on drinking water, this is bylaw to the Water Act, stipulates that the public water supply must be provided in the area of settlement with 50 or more permanent residents and with a settlement density greater than 5 permanent residents per hectare. And of course, we have also smaller communities as this one, and one of these communities in municipality of Ribnica. This is a small town in the central of Slovenia. They're trying to get the water supply for 20-30 years. And in this community, it's 11 houses and 25 people, aged from 6 to 80. And these people, they made an application to ombudsman. And ombudsman, in his reaction to the application, started the conversation with the local community. And of course, the local community had number of excuses why this part of community couldn't get the connection. And in his opinion, even in this case, that the community has not fulfilled the conditions by law, the ombudsman put in his decision that municipality in this case violated the principle of good governance, and that the petition is justified and suggests to solve this problem. I will skip the next one, not to be a little bit too long, and I will start another issue. This is suspension of supply of drinking water due to non-payment. It's also a very sensitive question. The Constitutional Court of Slovenia very early in 1998 ruled that the question of the interpretation of water supply do not that this interruption is a permissible measure due to non-payment. But be very careful. This is from 1998, and from this year, I think some legal values a little bit changed. We have in Slovenia quite new Electricity Supply Act, and in field of electricity supply, also the European Union adopted a directive about an electricity supply, also put in the center of this directive so-called vulnerable customers. This is the people who's not in position to pay the electricity, and also in this case the legal rules of the directive demanded the protection of such consumers. It's not allowed to interrupt the electricity supply even in case of non-payment. And of course, Slovenia, as a good member of the EU, harmonized its national legislation with this rule and put these rules to protect the vulnerable consumers in its legal order. On the other hand, we have the right to drinking water as a constitutional right, but no special rules providing the protection of consumers. And our suggestion was, from Vasilika and me in our paper was that the law in Slovenia should change, and the same mechanism of protection of vulnerable consumer should be also imposed for the drinking water. And I'm quite glad that one of our reviewer this proposal found as a very good proposal. But we also have different praxis. For example, also another case by ombudsman in city of Ljubljana, the capital. The ombudsman got a letter from a single mother with 2 children asking for intervention due to, by her opinion, unjustified disconnection of water. The local company from Ljubljana explained this interruption, and also the ombudsman saw that this interruption was justified. The lady didn't pay the bills for the water. However, ombudsman made a letter to this local company, described that this young mother is in a very tough position, and especially the children, how they really need the water. And after this letter by the ombudsman, the local provider, the company, changed the mind and connect this family to the water supply again, and gave the young lady the opportunity to pay the old debt in the installments. And of course, the local company reported to the ombudsman about this case, and ombudsman assessed this conduct of the company as an example of a good practice. So the company was not obliged to do this, but for justification, this is the practice. It's quite interesting. Slovenia, as I said, has right to drinking water as a constitutional right, but in implementation we have huge problems. Thank you very much for your attention.
Dear professors, dear students, esteemed Professor Szilágyi, thank you for your invitation and the opportunity for me to speak about this very interesting conference. The paper of Mr. Juhart tackles a very interesting issue from the perspective of a person that works at a constitutional court, so in the field of constitutional law and justice. It is the problem of enshrining new constitutional basic rights and liberties in the Constitution, namely the right to safe drinking water and sanitation. It is well known that a constitution establishes the fundamental principles of state organization and functioning, and that is why it has 2 dimensions. A dimension that concern the establishment of the organs of the state, and the second dimension is the one of attributing the competencies to these bodies. But beside that, modern constitutions comprise a catalogue of fundamental rights and liberties, or if they do not have such a part, they have acts of constitutional nature that establish such a catalogue. Of course, this catalogue can be changed. The legislators, the constituent legislator, the delegate legislator can add new rights and liberties, but it cannot affect or eliminate those rights and liberties that have already been enacted. We are speaking about the so-called eternity clauses provided by the national constitutions that preclude the possibility to affect the existent rights and liberties. But what is the constitutional basis to add or to supplement this catalogue? The answer is human dignity. Human dignity is the source and basis of all the rights and liberties. The human being is not an object, but a subject of the law. As you can see on my PowerPoint presentation, I put some case law of the German Constitutional Court that considers human dignity as a fundamental right, the French Conseil Constitutionnel that considers human dignity a principle of constitutional value, the ECJ considers it as a general principle of law, and I've put a decision from the case law of the Romanian Constitutional Court, a supreme value of the state, and it has double nature, a general principle and a fundamental right in the same time. So legislators, especially the constituent ones, tries to identify the rights that originate from human dignity. It is an impossible mission to have an exhaustive list catalog, and that is why we can notice that specific right appears as the society develops or appears new challenges or needs. But our society is a textualist society. You cannot have only human dignity in your constitution. That's why you have to enshrine basic rights, fundamental rights. And enshrining them in your constitution is a guarantee that they will be observed. We know that in the experience of Hungarian Constitutional Court that we have a so-called invisible constitution. So human dignity can suppose a lot of rights and liberties. But it is, as I've told you, a guarantee to have them enshrined expressly, expressis verbis, in the Constitution. You know, the composition of the courts can change, and all the time the rights are in a continuous movement. The right to safe water. Such a right may seem new, but actually it is not. The societies and the legal world didn't recognize it, maybe, or the societies were not aware by its own independent existence of this right. Also, it has a long existence as part of other fundamental rights, like the right of life or decent living conditions. I can give you an example. You know, every constitution has the right to a fair trial enshrined, but some constitutions have the right to defend yourself. And you can ask, why to put the right to defend as an autonomous, as an independent right in your constitution? Because of historical reasons. And I go back to the Romanian constitution, and I have in Article 21 the right to a fair trials, and immediately I have the right to defend yourself. You can say it is enough, the first right, but no. The constituent legislator can develop this right and can put guarantees in the constitution. But it's an instrumental importance in some parts of the world that this right to become an independent one, even if it being in connection, of course, with life, with human dignity, with the right to health. But when a right become independent, when a right become autonomous, I cannot give an answer, but I can tell you that there may be a historical background, a social, economic, or political background that makes a right to be to have an own existence in a constitution. The right we are talking about, it's it's an absolute or a relative right, because it's close connection and link with the right of life, it is an absolute right, but its effectiveness is subject to state regulation. I see two main components, a procedural and a substantive one. So, the substantive one is absolute in nature. It cannot be denied, and no other action can affect it, because it's a general truth that quality water sustains life, being a sine qua non condition for the existence of it, of the life. I can mention that it is protected even through criminal means, so by the criminal code. And I can give you an example in Romania, a decision in which you have these developers who built block of flats, and it happened near Bucharest that a person built such a block of flats, and he connected the pipeline of the sewage water to the main fresh water pipeline. Of course, this is a criminal offense. But the person came to the Constitutional Court saying that, okay, but it didn't happen anything. Nobody has died. Nobody was injured. But the Constitutional Court said, regardless of this, it is a criminal offense that takes into consideration the jeopardize the human life and the quality of the water. So the threat, not the result. So the procedural part, I think, it is the most problematic of this right. And it is the subject of constitutional and legal limitations, regulations. As Mr. Juhart said, there can be identified a series of obstacles in assuring the substantive part of the right. Legal uncertainty, represented by the bylaws, and this is the system in Romania too. We have a lot of bylaws from the local communities regarding the procedural aspect of this law, of this right. Another obstacle: how to connect to the public water network. Economical value on the one hand, and on the other hand, you have the basic right. And I can mention a hilarious situation in the case law of the Constitutional Court. A block of flats, condominiums, they have only one principal pipeline that connects to the main pipeline of fresh water. A person wanted to connect his flat directly to the main pipeline. Imagine if 50 or 100 flats want to connect individually in the main public pipeline. It is almost impossible. And the court expressed that, yes, you have access to water, but you cannot have it individually with your pipeline. The third obstacle was the suspension of drinking water supply due to non-payment. And I will try to be short here. I will present a case opposite to Mr. Juhart. Actually, you think that the ombudsman has to protect the vulnerable persons. But I have here a decision of the Constitutional Court in which the ombudsman contested a law that provided the obligation of the supplier, it doesn't matter, electricity, water, heat, in case of non-payment of debts that are contested to the court, to continue to supply the respective customer until a final judgment will be delivered. The ombudsman considered that such a measure affects the right of the supplier to property and economic activity. The court performed a proportionality test between the two competing interest rights, the interest of the supplier and the interest of the customer, and maintained the presumption of constitutionality of that provision, giving precedence so to the interest of the customer. The court noted that such a measure has a legitimate aim, as it assures the basic needs of the human being, mentioning the need of water. The law is meant to satisfy such needs. That assures the subsistence of human being. Such an aim is legitimate. But unfortunately, the ombudsman didn't tackle the problem of vulnerable groups. So the ombudsman was defending the supplier, not the customer. So maybe that would have been a better issue to be raised and solved by the Constitutional Court. So the problem of vulnerable persons, not the problem of the interest of the the interest so a general public interest, instead to put this question to defend the interest of the supplier. However, I noticed that sometimes the procedural part of this right is a condition to exercise other rights, to obtain a building permit. In Slovenia, but in Romania, no. So you can build a house to have building permit, but without having this permit for connecting to the freshwater pipeline. Conclusions. I said that I will be short. So I think that this right is an expression of the Rio Declaration of Sustainable Development in the environmental dimension. You know, a declaration has no legal effect. It is soft law. And enacting a fundamental right, it has normative content, normative effect, and it is a legal instrument to fulfill the scope of the Rio Declaration. So actually, it is a right to the offered to the citizens, and not only state obligations. It is much powerful that such a right to be part of the general catalogue of rights and liberties. Thank you very much.